Okay, well, why don't we get started? We have a lot of ground to cover, so we'll get started now. Um, Thank you everyone for joining our webinar today. On behalf of Gowling WLG, let me welcome you to this session. It's called, as you know, Crypto Asset Trading Platforms Legal Developments. My name is Usman Sheikh. I'm the head of our blockchain and smart contract group at Gowling's. Just by way of a little bit of background, our blockchain and smart contract group at the firm has been immersed in the area of blockchain for at least 4 to 5 years now. We have, I would say, at least 30 to 40 professionals throughout our country who practice in this space from all different sectors, whether it's the capital market space, whether it's privacy lawyers, whether it's IP lawyers, whether it's litigators, and many, many others. In terms of our own practice, we represent some of the co-founders of Ethereum. We represent crypto platforms, such as those that we're going to be talking about today. We represent banks in this space, stock exchanges, pioneers, small startups, and many others. Our group is a little bit unique in the sense that we have taken it upon ourselves to also do quite a lot of speaking and education around the world on this topic, whether it's to help educate governments or regulators. So whether it's really addressing the member states of the International Monetary Fund or the Monetary Authority of Singapore, or assisting really our domestic regulators and governments, we've been very active in this area. If you'd like to learn a little bit more about our group, feel free to visit our devoted blockchain and smart contract website, which is linked within the invite that you've received. And you're also going to be getting, at the end of this session, an email with a link to the program and to our website as well. So perhaps just before diving into the substance of today's topic, I should note that this webinar that you're attending here today is really the first in a series of webinars on some of really the hottest topics that we're seeing in the blockchain space. Today's session, as you know, is on crypto asset trading platforms. Our next session, which is going to be held on May 27th, I believe, May 27th, is on non-fungible tokens, or NFTs, which have become all the rage right now. We then have another session after that on June 17th, which is going to be on stablecoins and also CBDCs, also known as central bank digital currencies. Our session after that is on DeFi, or decentralized finance, which is on July 15th. And then we have a session on September 16th on intellectual property and open source. And our final session in this series will be on October 14th, which is going to be on blockchain litigation. So what we're really going to do there is consider a lot of the leading cases in the civil space relating to blockchain, criminal, regulatory cases as well. So if you'd like to sign up for any of those, you should have received a link within the invite that invited you to this session. And you can simply click on that link and you'll then have a registration page that you can register. If you didn't receive that, you're most welcome to go to our blockchain and smart contract website and send us an email through there. Or you should feel free to sign up for our blockchain bulletin newsletters, where you'll get regularly updated with these sessions as well. Okay, so just a few other preliminary matters before diving into the substance of today's topic. I should note that this program is eligible for up to 1 hour of substantive CPD credits with the Law Society of Ontario, the Law Society of British Columbia, and in Quebec. And it may be eligible for up to 1 hour of CPD CLE credits in other jurisdictions. You'll get more information on that in the email that you receive at the end of this session. And then another, being lawyers, very important point is the disclaimer that is already up on the screen for you. And that is that the presentation today is really not intended as legal advice. For specific legal advice on the matters that we're discussing here today, and as they may relate to your project or anything you're looking to do in this area, please contact legal counsel to get specific advice for your project and your affairs. Okay, so with that background out of the way, let's get to the topic at hand. And to that end, I should say that I'm honored and I'm privileged to be joined here today for today's session with several legal movers and shakers in the area of crypto asset trading platforms and leading legal developments in the area. In my view, it's always best to hear from the speakers themselves on their respective backgrounds. So perhaps we can start with our external guest, which is Lilia Tessler, who's at Sidley Austin LLP in the United States. So Lily, did you want to go ahead?
Great, thank you, Usman, for having me here today. My name is Lily Tessler. I head the FinTech blockchain practice at Sidley Austin, which is comprised of about 20 to 30 lawyers around the world across different offices and practice areas, working in a coordinated fashion in order to serve our blockchain clients that range from some of the emerging technology companies to trading platforms to some of the bigger financial institutions that are investing in or partnering with digital asset blockchain projects. So pretty broad practice in terms of capabilities. In terms of my own background, I primarily focus on the application of the securities laws to blockchain digital asset projects in the US, both for blockchain companies that issue digital assets, trading platforms that support initial issuance, secondary trading, and custody of digital assets, as well as some investors that are launching private funds or registered funds in this area that relate to blockchain or digital assets.
Okay, thanks a lot. And Lily is being offensively humble about her accomplishments and her group's accomplishments. Sidley's FinTech and Blockchain Group was recently recognized as FinTech Practice Group of the Year by Law 360. And Lily herself is widely recognized as one of the leading US attorneys in the space as well, and is ranked as such. So perhaps with that background, I'd like to move next to Lorraine. Just so that there's no confusion, we do not have an office in a vineyard. That's a picture of Lorraine's vineyard, but Lorraine, why don't you go into your background a bit?
Sure, thanks, Usman, and thank you all for joining us today. I won't take too much time in introductions, but I've been practicing corporate commercial law for embarrassingly well over 25 years. Recently, well, not that recently, I guess 4 or 5 years ago, started getting involved with the blockchain group under Usman's leadership at our firm. And it's really such an interesting and nascent area. You know, every day there's something new that we need to learn about, and I find it extremely interesting. So I'm representing, my practice is primarily in the tech space, and I work with everything from startups on helping financings for startups all the way through to mature companies that are doing rounds of financing and raising capital, and doing M&A transactions. And so my clientele in this space is very reflective of that. I have a number of clients who are just starting out and wanting to understand where they fit in the regulatory regime. So I help them out from that perspective. And also, you know, just setting themselves up properly for future financings and capital raising. So it's a great area, and I'm really excited to be here.
Terrific. And I should note that Lorraine is the head of our business law department in the Gowling's Ottawa office. And she's actually authored, you can look it up, along with one of our associates, Shayla Ray, a really fascinating piece called Crypto Asset Trading in Canada, which was published by Banking and Finance Law Review just a few years ago. So I'll give a little bit of a push on that, Lorraine, for you.
Thanks, Usman, appreciate that.
Excellent read. So let's jump into the questions, if I may. And let's maybe start off with a few background and basic questions. We'll come to their benefits and the risks later on, but perhaps just as a starting point, what are crypto asset trading platforms? What are crypto assets? Maybe Lorraine, if you can start that off.
Yeah, sure. Thanks, Usman. It's a basic question, but for those, you know, maybe not on our entire audience is familiar with the terminology and what these things actually are, and a lot of the definition of what a crypto asset trading platform is. You know, this generates from how securities regulators are looking at this topic, and I think there's some differences between how Canadian regulators are approaching these platforms versus how they are in the US. So I think it's really beneficial to have Lily here to speak to the US angle on these platforms. So I'm going to give you a high-level overview of the nature of crypto asset trading platforms, which is also going to involve necessarily some discussion of the definition of crypto assets themselves and how Canadian securities regulators define these platforms and the assets. In a nutshell, crypto asset trading platforms are online trading facilities that allow investors to buy and sell crypto assets. So things like Bitcoin, Ether, coins or tokens that have been sold through initial coin offerings and initial token offerings. The Canadian Securities Administrators define these platforms as any entity that facilitates transactions relating to crypto assets, including buying and selling crypto assets. So these platforms often refer to themselves as crypto exchanges, but the Canadian securities regulators, they don't want to call them exchanges because they feel that that conveys the idea that these platforms are regulated in some way just because they're called an exchange, like the Toronto Stock Exchange, for example, or the NEO Exchange or the Canadian Securities Exchange. When people hear those terms, they know those are regulated entities. Right. And so, you know, in my view, Usman, I don't know if you agree with me or not, but my view is that you know, the regulators really hesitate to call them exchanges and prefer to call them platforms, and that's why they come out with regulations around crypto trading platforms instead of calling them exchanges.
And we do that as well. We typically use the word crypto asset trading platforms versus crypto exchange. But
right, just to give that delineation between the type, the nature of the entity that we're discussing. So these platforms often perform functions similar to, they could perform functions similar to a stock exchange, to marketplaces, to alternative trading systems. They could provide custodial services, act as a dealer or a clearing agency, all of which makes it very difficult to fit them into existing securities regulations. To provide some examples, there's over 300 of these platforms currently listed on CoinMarketCap, which is an entity that ranks and scores crypto exchanges based on traffic, liquidity, and trading volumes. So some you may have heard of and would include entities like Binance, Coinbase, Kraken, more infamously in Canada, Quadriga CX. I was reading this morning about Bitco and Bitso joining the ranks of, there's over 20, I think almost $30 billion valuation unicorns in this space. So they're getting valued at significant valuations by venture capital firms and traditional financing firms. As I mentioned, any conversation about crypto trading platforms necessitates discussion about the crypto assets themselves. So broadly defined, crypto assets are financial instruments, electronic money, tokenized instruments, any sort of instrument that carries rights that may traditionally be attached to shares, like voting rights or dividend rights, but also anything that provides an option to acquire an asset in the future. Crypto assets can be commodities, and the platform user's contractual right to the crypto asset may be a derivative or a security, like an investment contract. It might be evidence of indebtedness or evidence of a title to or interest into certain assets or property of another person. There are also utility tokens, which allow holders to access or purchase goods developed by creators of the token. And those have generally been determined to involve a distribution of securities in the form of investment contracts, while others, such as Bitcoin, would function more as a payment or means of exchangeable currency with features like a commodity rather than a security. So with such diversity in the assets being traded on these platforms, an evaluation of how trading occurs is often required in order to assess whether or not a security or a derivative is actually involved in the platform. And in doing that, there's a variety of things that are considered. That would include whether or not actual delivery of crypto is happening to investors on the platform. If so, when that delivery occurs, and whether that delivery is actually to an investor's wallet outside the platform, or does that platform actually have custody and control over the crypto? So whether or not the assets are pooled together with other assets of other investors and assets of the platform is also a big consideration, and whether or not the platform holds or controls the investor assets, and if they do, how do they use those assets? So there's a lot of considerations that go into determining the nature of the trading platform. in guidance that was issued by the CSA in January of 2020, it was indicated that platforms that provide their users with a contractual right or claim to an underlying crypto asset rather than immediately delivering the crypto asset to its users, those are generally subject to securities legislation. In circumstances where the underlying crypto asset is not a security or derivative, and the contract or the instrument of the purchase or sale or delivery results in an obligation to make immediate delivery. So if it's being immediately delivered, it's not an actual security, and it's being settled immediately by delivery of the crypto asset to the user's own wallet, then and that is how the platform is typically operating, then that, in those circumstances, that platform may not be subject to securities laws. So from an immediate delivery perspective, this basically means that the sale or purchase of the crypto asset is not merely evidenced by an internal ledger entry in the platform, but there's actual transfer of the currency to the user's wallet. And following that transfer, the user would not then be exposed to any insolvency risk or credit risk or fraud risk or performance risk on part of the platform. So sorry, go ahead, Isman.
No, so I was gonna, and some of this we're gonna get into as well in terms of how the platforms are regulated. So maybe we can chat about that in that context, but let me maybe turn it over to Lily, just to maybe give some background on, your thoughts on what crypto asset platforms are and what crypto assets themselves are as well, just to give a bit of a primer to the audience, if you don't mind.
Yeah, no, happy to add to Lorraine's explanation. I think a lot of the considerations that she outlined under Canadian law would be relevant in the United States as well. Just one premise before I get into what a crypto asset is the U.S. regulations typically are triggered if an entity, a crypto trading platform, is offering services to U.S. persons, or offering the products, the crypto assets, to U.S. persons or within the United States. So although it may be the same analysis, first you have to start with the premise: are you offering the services to U.S. persons or within the United States? And so if you are, the crypto asset itself, you have to, similar to what Lorraine said, look to what does that asset represent? Is it effectively have some type of use and functionality on a blockchain? And does it have some type of other security-like features that may make it a security? Does it clearly fit in within the definition of the broad securities laws? Specifically, the Securities Act of 1933 is what we look to. Is it one of the statutory types of security? So, for example, is it tokenized equity? Then it's clearly equity within the securities laws. Or is it have security-like features, but really also has functionality? And there we may get into analysis of whether it's an investment contract, which is, I think, a similar test in the U.S. to how we test as in Canada. So, those are just two examples, but there's a number of enumerated types of securities that could fall under the securities laws and that could represent a crypto asset under that regime. But there also is the world of commodities and number of digital assets. For example, Bitcoin, Ethereum, the SEC, certain staff members have said are not securities and therefore are commodities and are regulated as commodities by the CFTC to the extent there are market manipulation, and we'll get into later as to how regulations apply to those commodities. But almost all digital assets, crypto assets, are commodities. It's just that if they are securities, the jurisdiction falls within the securities laws as opposed to the commodities laws on those assets. And then there could be certain assets that are used as a form of payment, in the U.S. referred to as convertible virtual currencies that fall into some other regulatory regimes. And there may be overlapping definitions based on what those assets represent. And so those may be a form of payment on a particular blockchain network or on a particular platform as well. So there are a few different types of crypto assets that we look at. And it ultimately goes to what is the utility and functionality of that asset, but also how is it offered to the general public? What promises and statements are made by the developer or issuer of that crypto asset that may be embedded in some instances into that crypto asset, or it may not be embedded because the features and functionalities or the way that the general public may use, or the reason they're acquiring it, may change over time as well. And so the characterization of a crypto asset may change as well. And so we'll talk a bit more about how the regulations may vary on that in that respect.
Yeah, so I mean, these crypto asset trading platforms come in a whole wide variety. We've seen pretty much, I thought I saw every variation, and then I came across a new variation the other day. Welcome to innovation. But really, what we think of crypto trading, asset trading platforms are platforms that allow a user to basically buy and sell digital assets. And people will go on the platform and buy the crypto asset through fiat, like USD, Canadian dollars. We've seen wire transfers, debit, credit cards, or even other crypto assets being used to buy other crypto assets. So Bitcoin for Ether, et cetera, et cetera. And the models have really changed. Like, I mean, Lorraine was talking about in some circumstances, they're custodial crypto asset trading platforms. That's a big category of platforms. That's the majority of them that I've seen, which is where the platform is actually custodying and holding the private key for the crypto asset. They're not actually giving immediate delivery, as Lorraine was saying, to the user. And therefore, they're the ones who sort of hold it on your behalf. And then you have non-custodial crypto platforms, which do involve immediate delivery of the crypto asset, meaning there's actually an on-chain transaction that changes ownership to that crypto asset, if you will, or the control of that crypto asset to you or myself. And I think what we're talking about here in terms of these crypto asset trading platforms is that what's kind of unique about them is that there's a whole wide variety of crypto assets that are oftentimes supported. Some say listed, but we'll try to stay away from that word on the platform. So I encourage everybody who's in the audience to even type into coinmarketcap.com and run your finger down the list of the 3,000 tokens that are listed there. And you'll see some that are what we call native assets, being things like Bitcoin, which is a native asset to the Bitcoin protocol, which is a token that is sort of spit out of the system to incentivize what are called miners to mine. Same thing with Ether to Ethereum. You then have tokens that are supported or listed on these platforms that are ICO tokens, which we call, many of them are ERC20 tokens based on the codings, is a word that you'll often hear. And they sometimes were issued to capital raise, or they may offer some functionality within the blockchain project's platform that they're creating. There's also stable coins that are listed on these platforms as well, that are tokens that are kind of tied to or pegged to some other outside asset like the US dollar or gold to sort of help stabilize its price. And now what we've been seeing as well are NFTs, which is a different type of token. Instead of an ERC20 standard behind it, it's ERC 721 oftentimes, that are also now being put on these platforms. I guess the overall point is that these things, crypto asset trading platforms, are quite unique in the sense that not only are they as an entity unique, but the tokens or the crypto assets that they support, each will have its own sort of genesis, if you will, its origination. Each will have its own purpose for creation. Each will have its own different use, which from a legal perspective, and I think Lily, this is what you're getting at, and Lorraine as well, is that the treatment of each of these tokens may be different, which has implications for the platform itself. In some circumstances, it may be a security. In other circumstance, it may be simply a currency. In some other circumstance, it may be something else, which will implicate and sort of feed into the legal issues, which we'll talk about next. So before we get there, why are these crypto asset trading platforms so hugely popular nowadays? What are their benefits? Why do people go to them? I'm not sure, Lorraine, if you wanted to start that off.
Yeah, sure, Usman. I mean, those are all great points, and it does take you taking a step back and looking at that list. See, there are so many different crypto assets and so many different platforms out there, and so it's a really it's fascinating, and things are changing constantly. From the perspective of an investor, in terms of the benefits of these platforms, well, I think probably the largest benefit is it provides a platform for people to trade their crypto assets. And so rather than me having to go peer to peer with somebody if I want to trade my asset, I facilitated. It provides a facilitation of that trade for me. And hopefully, people that are using these platforms, the platforms that they are using are, if they aren't registered, they're at least following, sort of high standards and protecting the assets in the transfer. And that kind of brings us into I think from the perspective of benefits, I think the biggest benefit is it provides a liquid market, because otherwise you may hold an asset that doesn't have any liquidity. From a risks perspective, however, like there are a lot of risks in these platforms, and I think, Usman, we've been talking about, regulators have been for a number of years urging caution. They issue alerts on a regular basis, investor alerts, cautioning Canadian investors that are using these platforms that even though they call themselves an exchange, that doesn't mean they're complying with securities laws. And if they aren't, that means that some very key investor protections might not be in place. And so things like the secure handling of investor funds, protections against market manipulation, I think Lily mentioned that. There's other harmful practices like price arbitrage. So people might buy their crypto on one exchange and then sell it on another exchange where the price might be higher. And protections against that type of activity may not be in place for platforms that are not regulated. And regulators in Canada have issued papers on the risks to investors that are using these platforms. So you can access those papers and you can see what the regulators view as the risks to the platforms. But most notably, I mean, Quadriga CX, it's a $260 million loss by users of that platform when their founder suddenly died. And that demonstrates the risks in the platforms that, if they're exercising control over participants' private keys, if they're gone, you might not ever have access to the monetary value that crypto represented. So appropriate custody and control and segregation of assets from the platform's assets, these are all really important parts of managing risks. And because, if you don't have those in place, then, if that private key is lost or the platform is insolvent, the investor is going to be out of luck, right? So,
Yeah.
So, in addition to the financial losses, though, there's also risks relating to the integrity of the platform itself. So you can't lose sight of things like cybersecurity. And, I guess, if you've got a private key, then maybe you're sure that you have absolute security of that key on the blockchain, but that also centralizes that risk of a security failure. So if that private key is compromised, then the crypto assets can't be transferred and they may never be recovered. And so a compromised private key, that could be an issue as well. And there's also, blockchain is providing it provides sort of higher levels of cybersecurity because it's a decentralized, platform. But again, if you are centralizing that decentralized platform with private keys, then that creates a potential for a single point of failure. So there's no, another thing that people need to be mindful of is that there's no standard of quality or threshold for a crypto asset to meet before it's made available for trading on a given platform. So, although one of the significant benefits may be liquidity, there's often not a lot of information out there regarding the actual liquidity of that asset that's available to investors. So participants, they need to understand that how prices are determined and whether or not the price is fair before sort of getting into the trading game under all the excitement of the buzz of these assets.
Lily, what about yourself? What are sort of the key benefits of these platforms? And Lorraine started talking about the risks. What are the risks as well?
Yeah. So in terms of, I agree with everything Lorraine said, not to duplicate in terms of some of those benefits and risks. In additional ones, just counteracting, I know Lorraine discussed some of the risks related to custody. I would say that's also custody on an exchange also carries benefits, principally because for individuals, retail investors in this area, they don't know how to create their own private key, how to create their own wallet. They don't, on their own, but for having a crypto trading platform do that for them, they have no way to access the crypto market. And I think crypto exchanges have created access to Bitcoin and other kind of commonly known crypto assets in the market that everyone's heard of right now You can just open an online account on some of these exchanges and have them take care of all of the back-end infrastructure and including custody of the assets. Certainly, it's important to conduct due diligence on that exchange to ensure it's properly regulated and has proper controls, but there is a benefit to having an exchange deal with all the custody as opposed to having individuals carry and secure their private keys on their own in this space currently. Another benefit I wanted to mention is valuation. The exchanges provide pricing for a lot of crypto asset specific products. A lot of the, for example, derivative products that have been created or Bitcoin ETFs that have been created, the pricing feeds are generated by some of the common known crypto trading platforms. And it's also a method by which a lot of the accounting firms and others that need, even private funds that need to value assets that are but for crypto exchange would be very hard to value. And so that's another benefit that I think the crypto exchanges bring. Certainly one of the both benefits and I guess one of the risks is the immutable nature of the blockchain. So when you transfer the assets to a counterparty, that even if it's by accident, it's non-reversible on a blockchain. And so I think even though you're not transacting directly on a blockchain, you're transacting through an exchange, a lot of the same risks will pass down to the user. So once you've effectively a transaction on that exchange, you can't reverse it. Especially, and I think this risk exists if you're moving assets off of an exchange to another wallet or to another exchange. There is that risk of loss that occurs.
Yeah, I remember back in 2017, and I think that this is actually when I first met you, Lily. It was really during the first wave of fascination with this technology, with the ICO boom. And what we then saw was sort of interest wane. And now this whole second wave of interest in crypto assets and crypto platforms, largely because of what I'm seeing is three things. One is the price of Bitcoin. It's, as I understand it today, at $58,000 per Bitcoin. Other crypto assets are similarly have increased significantly. Bitcoin used to be $3,500 in January of 2019. So that's a significant increase, and we're seeing retail purchasers and even now institutions getting in. We're seeing a lot of fascination with NFTs, DeFi, crypto listed funds, and just this growing maturity in this area that more individuals and institutions are getting into this area. I mean, we even just, Lorraine, you had mentioned some valuations that we've been seeing. I mean, one crypto platform just went public through an IPO with a tremendous valuation. So the reason why crypto platforms have become this big area of interest now is exactly the reasons that you're talking about, is that, among other things, the general convenience. People don't know how to manage their own crypto assets themselves. It's way too technical. They don't want to just have their token on their phone and find some other party peer-to-peer to trade their Bitcoin or their Ether or whatever it is. They want liquidity. They want the ability to find a counterparty easily on that transaction. And they want the ability to be able to remove the token from the platform as well. And as Lily, you were saying, I mean, there's a lot of benefit to having a platform cold storage your crypto, air gapping it, and taking extra precautions on cybersecurity to manage those crypto assets. That being said, as Lorraine properly mentions, there's also cybersecurity risks, and we've all heard about those cybersecurity hacks of crypto asset trading platforms and others. So anyway, I thought I'd sort of just mention my thoughts on that. So I was going to speak next, if I may, just about how we've seen the evolution of platforms really in Canada and the evolution of regulation as well. In truth, it's been a pretty interesting progression from a Canadian perspective. And Lily, I think you'd probably agree with me from a US perspective. Most of the securities regulators largely came to this area rather late. And I don't mean this as any criticism, but it is just oftentimes the sheer reality of innovation. Oftentimes regulators are coming to the area much later. And by that, what I mean is that Bitcoin's white paper, in fact, came out in I think it was Halloween of 2008. And the Genesis block was, created back in January of 2009. The really first guidance that we saw from a Canadian securities regulator came in 2017. And so just based on that timeline, you can see that it's almost 10 years later, there was already a lot of activity in this space, a lot of interest, many tokens being issued, many crypto platforms being issued. And so what we then saw, and again, I don't mean this as any criticism to any regulator, it's just, it is what it is, and that's not uncommon in the innovation space, in fact. But what we started to see in relation to crypto platforms is that in the early days, much of the discussion and focus was on ICOs versus crypto platforms. And Lily, you may have seen this in the United States as well. And it was only recently that more guidance was being issued, specifically with respect to crypto platforms. In truth, though, and in fairness, in some of the earliest guidance that was issued by the CSA, and Lorraine has mentioned the CSA a few times, and for those of you who are less familiar with Canadian securities or regime in Canada, we don't have a national capital markets regulator like the United States, like the SEC or the CFTC. We have 13 provincial territorial regulators, and really the CSA is a body to help act as a forum to allow them to communicate, try to harmonize their approach, take positions collectively, and do other things. And so in some of the earliest CSA notices, we do see mention of crypto platforms, and there are risks being identified, and they are mentioning to platforms, look, you should check whether you are triggering the marketplace requirements under Canadian securities laws. And if you do, you may need to comply with the rules that relate to exchanges or alternative trading systems. And we then saw, following that early guidance, more information coming out, including investor cautions relating to crypto asset trading platforms, telling the public that to date, as of that date, the regulators have really not recognized or otherwise cleared any crypto platform to really operate as a marketplace or dealer in Canada. And then we had Quadriga CX happen. And that was in February of 2019, where you have Quadriga file for CCAA protection, so creditor protection, one of the largest crypto asset trading platforms in Canada. And Lorraine, you'd already mentioned this, but it was a pretty significant moment. I mean, I remember the day that happened, and I received literally in one day, 700 phone calls, totally overwhelmed, because so many parties had suffered in that as being, because they were somehow involved in or had their assets tied up. And specifically, according to the regulators and the monitor trustee for the CCAA proceeding and subsequent bankruptcy, they determined that about 76,000 clients were owed $250 million. And in that case, the trustee was able to recover about 46 million, meaning that there was a loss of about 170 million. So there was a lot of global outcry at that point, which really brought to the fore, like, what is the regulatory regime that will apply to these things called crypto asset trading platforms? And for those of you in the audience who have not had a chance to read the monitor's reports on what happened in Quadriga CX, or the Ontario Securities Commission's staff's report on Quadriga CX, I encourage you to do that. That being said, I would caution that the OSC staff report are not findings of the commission as such. They're findings based on an investigation by OSC staff. And shortly thereafter, the regulators start putting out a proposal. And I can tell you the first proposal came in March of 2019, just a month after Quadriga CX, but the regulators, the CSA, was almost certainly working on this well before, trying to figure out what regime should apply to these things called crypto asset trading platforms. And they asked for various input from the community, saying, here's the framework that we think should apply. We want to, and here are the risks that we see. But this thing is new and novel. We've not really come across an entity that has, as Lorraine was saying, all these different functions kind of combined into one, clearing and settlement, dealer functions, exchange functions, and many, many other things kind of all embedded together. So that's why they said, look, this is very new, novel, we want input. They received over 50 comment letters. And just a little while ago, they set out their position with respect to what that regime should look like. I should mention as well that before that occurred, a company by the name of Wealthsimple did receive an exemptive relief order, becoming one of the first, if not the first, crypto platform to receive what's called exemptive relief, meaning some relief from our standard requirements that would typically apply in order to allow their project, which was Wealthsimple Digital Assets, to be able to allow certain users to buy and sell what are called crypto rights contracts through that platform. So I thought I'd just sort of set the scene, if you will. We'll talk about how these things are regulated now and what that March 29th notice said. But I don't know, Lily, if maybe you can talk about whether the United States had a similar progression in terms of its development, or was it very different? Was everything clear from the start, or how did things progress?
Definitely not clear from the start. I don't think it's even clear yet as to how these regulations evolved. And I would say the regulations also have evolved. At least in Canada, you do have one regulatory regime, although different provinces. In the U.S., the guidance evolved differently from different regulators. So we have the SEC that regulates securities markets and securities intermediaries, with FINRA regulating broker-dealers. And then we have the CFTC that regulates any futures, derivatives, and swaps on commodities, and also enforces the Commodities Exchange Act. We have FinCEN that regulates the activities for convertible virtual currencies I mentioned earlier, and also various state regulators, state banking regulators that regulate this activity for some of the crypto trading platforms. So just to name a few different market participants, and so regulations not even regulations, more informal guidance dribbled from each of these regulators over the years. Certainly FinCEN, in its focus on enforcing Bank Secrecy Act and anti-money laundering, put out early guidance in this area regarding convertible virtual currencies and how those should be regulated. But also, the securities laws, I think is most relevant to this discussion. The first guidance the SEC formally put out was the Dow report. I think shortly after Canadian regulators put out their initial report, and that focused on initial issuance of unregistered securities, although there were some footnotes in that report that related to intermediaries and when you need to register as a broker-dealer. And keep in mind there's the 34 Act and the Investment Advisors Act for advisor participants in this space. So that was the early guidance. Most of the other guidance as it developed over the years from the SEC really were through settled enforcement actions. The SEC brought first against fraud and market manipulation in this area, and then really was the way they shaped some of the informal guidance on the application of the how we test investment contracts was through settled enforcement actions against some of the ICO issuers in 2017 and 18. In 2019 was the first time we saw public statements from various cross divisions across the SEC, trading and markets, investment management, and corporation finance regarding the need for trading platforms to be, if they're supporting digital assets or crypto assets that are securities, to be registered and regulated by the SEC and possibly FINRA if there need to be broker dealers. So that was really the first time there was a focus on crypto trading platforms. In 2018 and 19, we saw some of the first settled enforcement actions against an unregistered broker-dealer, which was the token law case, and an unregistered national securities exchange, which was Ether Delta. And those are the two that I think really, and probably the only ones to date that focus on intermediaries of crypto trading platforms and their need to register. We since then have had more guidance, but most of it is focused on whether certain digital assets are or aren't securities from the SEC's now division, FinHub, a new division with the SEC focused on fintech companies and blockchain guidance. Although that guidance is instructive for crypto trading platforms, because depending if the assets they support are or aren't securities, then that will determine if they need to be registered by the SEC. And if it's not a security, then they need to focus on whether the asset effectively is a commodity and their operating spot commodities exchange. It needs to be registered with FinCEN at the federal level, possibly, and various state banking agencies as a money services business. So those are that's kind of been the evolution on the securities side. I'm not going to focus too much on the CFTC side, but there also has been guidance over the years on how to regulate and think about swaps, futures, and derivatives on digital assets, and those entities that are supporting trading of those assets need to be separately registered with the CFTC as an FCM or a SEF or other appropriate regulations.
So if I can continue, if you don't mind, to keep picking on you, because I would like to actually ask you as a lead on to that particular background, is how then are crypto asset trading platforms regulated in the United States? I actually teach at U of T Law on blockchain and recently had SEC Commissioner Hester Peirce, and I was surprised to hear, in fact, that the SEC doesn't weigh in as much as I would have thought. You've heard a little bit about this crypto rights theory, which is that in Canada, which is that even if a platform is not trading securities or tokens that may be viewed as securities, which is the common view of Bitcoin and Ether, that because you, Lily, on your phone would have 5 Bitcoin, but it's being custodied by somebody else, there's a contractual right, and that's created either a security or derivative relationship, and therefore the securities regulators have jurisdiction because there's trading of securities or derivatives going on. I wouldn't mind you to tell us what's the state of affairs in the United States then. How is it regulated?
Mm-hmm. So for traditional assets outside the crypto space, there are broker dealers that are regulated by the SEC and FINRA that support trading of assets that are commodities, that are not securities effectively. They even hold assets such as art for their customers that are effectively not securities. But for purposes of the novelty of crypto assets, the SEC and FINRA together have published joint statements and are concerned about a registered broker-dealer at this point, given certain risks related to custody and the blockchain technology and its novel nature, to support trading or custody of digital assets that may not be securities. They really, at this point, and I think there may have been kind of early years, certain broker-dealers that have supported and gotten approval for non-security digital assets. But now currently, especially with the most recent custody statement that the SEC put forth in December 2020, for a broker-dealer to custody digital assets, it needs to have a level of comfort those assets are securities. It explicitly prohibits the ability for broker-dealers to custody non-security digital assets. So that has to be part of their policies and procedures. Over time, that stance may change. It's more of a policy view from the regulators as opposed to broker-dealer not being able to hold the commodities generally for trading or custody, but that's currently the stance and the way that typically broker-dealers handle this. I will say that the SEC generally has taken the view that many digital assets fit the bucket of being an investment contract and therefore a security. So over the last, I think when I was in this space 2016 and 17, everyone wanted to try to fit in the bucket of being a non-security digital asset because there weren't no broker dealers being approved to support a digital asset securities marketplace. And so because of that push, a lot of crypto assets registered with FinCEN and state banking agencies, and that's how the non-security crypto market developed, and that's where most of the crypto trading platforms are in the US currently. But over the last couple of years, as we saw more guidance, SEC and FINRA supporting the development of the digital asset securities market, and I've been actively involved on behalf of clients and even industry groups and pushing the SEC for more guidance on how, if you do believe these assets are securities, how can you support a marketplace for them as opposed to driving more people to take a view that these assets are not securities since those markets exist. And in light of that, over the last, I think, year and a half, various broker-dealers have obtained approval for initial issuance and secondary trading of digital assets that are securities, non-custodial and in nature. I think that stemmed from the July 2019 statement from FINRA and the SEC on this topic. And then even September 2020, the SEC released no action relief for non-custodial ATSs to support trading of digital assets that are securities. And since that statement came out, the SEC has approved, actually they don't approve, but allowed registration for certain broker-dealers to support ATSs in the digital asset security space. And now with this custody statement that just came out in December, there's a number of other applicants in the pipeline to support custody of digital asset securities markets. So we are seeing this development of a regulated marketplace to support those assets under the SEC's existing regimes.
Interesting. Lorraine, in the interest of time, just do you want to cover how things are regulated up here in Canada?
Yeah, sure. Usman, I was just going to comment, in terms of, I think you had alluded to it a little bit in what you were saying through the history, but from a Canadian regulatory perspective, the platforms themselves are looked at as to whether or not they are a marketplace or whether they're providing a dealer function. So if it's a marketplace, then that means what the marketplace is, the platform is doing is it's maintaining or providing a market or a facility for bringing together multiple buyers and sellers, and allowing them to trade their security or tokens or crypto contracts. And in that instance, then how those are regulated are under our national instruments 21101, applicable to marketplace operations, or national instrument 23101 with respect to trading rules, and then 23103 with respect to electronic trading and direct access to marketplaces. So there's the marketplace piece that's regulated under certain aspects of our securities legislation. And there's also the IROC's Universal Market Integrity Rules, which will apply to marketplace trading. So there's a couple of layers of regulation around the marketplace platforms, because securities regulators would expect that a marketplace platform would apply for registration as an investment dealer and seek IROC membership as well, so that there's integrity rules that are governing the operation of the marketplace. If the platform is providing a dealer function, then so from a dealer perspective, it's providing custody of crypto assets and permitting direct access trading by retail investors. Then the regulations that currently exist that are consistent with those that apply to dealers, registered dealers, would be applied to crypto asset trading platforms that are providing that service. So that would be National Instrument 31103 with respect to registration requirements and exemptions and ongoing registration obligations, and also the IROC dealer member rules. So a slightly different forum, but depending on the function that the marketplace or the dealer is providing, that the platform is providing. So what I'm understanding is that currently, if there's an exempt market dealer, that it's currently permitted to under securities legislation to facilitate trade and sale of securities, including crypto assets, then and they're doing that in reliance on prospectus exemptions, then those should be permitted to continue to do that, as long as they don't fall within the definition of what the securities regulators deem to be a marketplace. So a little bit of distinction there. The other thing I just wanted to mention too was again about exchanges. So if a marketplace is conducting itself as an exchange, then that entity should be conversing with regulators and determining whether or not what they're doing is appropriate to be dealt with and registered as an exchange, or if it's more appropriate for it to be dealt with as a marketplace or a dealer platform. And in those instances, if an entity is acting as a true exchange, then as our exchanges are required to do, they need to have a whole sort of regulatory regime and rules around the participants in that exchange and make sure that they are enforcing the rules of the exchange itself. So there's a whole nother area of compliance if what's being done is operating as an exchange.
Yeah, so final question, I guess, is where is this all headed regarding crypto platforms? So from my perspective, in Canada, I see people sort of answering the call from the regulators and the regulators said, look, we're willing to give interim measures, you a different category of registration while you sort of acclimatize to the full shebang, if you will. And so I expect to see, and the rumor has it, and reports have been issued by various news outlets, that a number of people have come forward to take advantage of that, to either take that interim measure or to move towards the full regime. We have seen that because of this regime, whether it's correct or not correct, some parties have decided to exit, and they'd rather not be a first mover in this space, and they've decided to make that business decision to do that. They find that the regime is too onerous, again, rightfully or wrongfully. And I expect that we will see a lot of enforcement in this area, both from the regulators, but also civil private enforcement through civil litigation against domestic and foreign crypto platforms. I do expect, in the context of that litigation, this theory of crypto rights to be challenged. I know that the street, the legal bar is not entirely unanimous in their view that that is a supportable position. So, which case that issue is raised has yet to be seen. Trying to exercise some prophetic view as to where this is headed as well. I mean, Lily, you had mentioned Ether Delta. I mean, that is a DEX, a decentralized exchange with, totally made up of smart contracts and sort of like a DAO, like a decentralized autonomous organization where just a collection of smart contracts, you kind of create them and then they do their thing effectively. And sometimes there are humanoids that are somehow involved in some fashion or another, but sometimes they're not. And so the question will be is, how does this regime interact with that? Once it's created, how do you stop it? So it'll be interesting to see that angle of things. And then we've been seeing a lot of attention on NFTs and DeFi, but I'll sort of save my views on that for the next sessions that we have. But I see easily, the issues raised in this discussion today potentially arising for those platforms as well. But maybe, Lily, if we can go to you next in terms of your views as to where things are headed and what the future has in store.
So I think certainly if the few topics that you mentioned are relevant in the United States as well. We're seeing a lot of market participants being driven towards DEXs, decentralized exchanges, and first because certain assets are supported on those exchanges, or they're taking advantage of arbitrage opportunities on these decentralized exchanges as compared to some of the centralized crypto trading platforms. So there's definitely a drive and a number of decentralized, not just exchanges, but we're seeing decentralized lending platforms and decentralized insurance, even decentralized issuers, and that's an area where I think that the various U.S. regulators and certain states have opined on how you can have decentralized issuers. But the challenge from a regulatory perspective, because that's the perspective I usually get these questions from, is the regulations are written for intermediaries. Having crypto trading platforms and others regulated and having a regulatory regime around that, while the market is moving to this decentralized environment where counterparties are interacting directly with each other and taking on those risks. And some are trying to figure out how to build in decentralized compliance software to mitigate those risks on a counter by counterparty basis and so forth. So, all those are all those products on the decentralized side. It will be interesting to see how the regulators react to them. I've had informal discussions with U.S. regulators on how their existing regulations may intersect with these products, but it's really in the early stage of understanding how the regulators will be viewing some of these products in the near and long term.
Okay, Lorraine, final thoughts on that question?
My only thought, in addition to what Lily said, is, I mentioned the billion-dollar valuations that we're seeing being obtained by crypto asset platforms. And that, to me, is one indicator of where the future is going and the nature of those businesses that are getting those valuations. and raising that kind of capital. And those types of platforms are doing things like offering services to keep crypto assets secure from theft and loss. They're offering portfolio management and ways for financial institutions to integrate digital currencies into their own existing financial systems, and enabling trading of crypto from mobile phones and creating keyless crypto wallets. The nature of those businesses that are garnering that type of attention is, I think, a good indicator of where the market is going in this.
Yeah. So I didn't realize this, they just popped up on my screen for some reason, but as it turns out, there are a few questions in the Q&A. So I'll just handle them very quickly, and then Lily and Orion, you can sort of correct me where I'm going wrong on anything. One question is, are NFTs securities? It really depends. And so whenever we get an NFT project, one thing that we do look at, among other things, is whether the NFT could potentially satisfy the definition of a security, either under the standard definitions of what a security is, or through this investment contract test. So if you go to the Ontario Securities Act and you look at the definition of security, there's 16 things that would constitute a security. One does a test under each one of those. One of those things, being the 16th or maybe the 15th, is an investment contract test. And that is a very common test that is applied to determine whether something is a security. And that's a very good question. And that analysis does have to be run on any NFT that is being issued. Somebody asked, please clarify what an ICO stands for. ICO is an initial coin offering. Usually think about it as a lot of projects that are blockchain-based projects would, in the early days, issue tokens. Oftentimes they would take in funds by issuing these tokens, saying that, in the future, we're going to build this project, and this token is going to have some functionality within this project. And, oftentimes people who bought those tokens may expect a gain later on, because those tokens that they just bought may trade on some other platform, which raises securities law issues, including because that token may potentially be captured as a security under the investment contract test or some other test. Another person asked, what are the specific exemptions that Wealthsimple required? So to my recollection, they were seeking a prospectus relief from the prospectus requirements in respect of what are called crypto rights contracts with clients to be able to purchase and sell crypto assets. So going back to the fact that perhaps Bitcoin and Ether may not be securities, that being said, to the extent that the user is not holding that crypto and the crypto is being custodied by, in this case, Wealthsimple's digital assets, that may have created a contractual right, which is a security in and of itself, is the view. And so they were seeking prospectus relief from the requirement to have to issue a prospectus in relation to that. They also sought an exemption from the requirement to deliver audited financials and a few other prospectus exemptions, a few other exemptions as well. And then another question is when will IROC regulated security dealers be allowed to offer their clients the ability to buy and sell digital coins, assets, and security tokens, just like they do stocks? I don't know, Lorraine, if you had a thought on that. I mean, really, they have to go through this regime that has now been further elaborated on by the securities regulators, but I don't know if you had any thoughts in relation to that.
Yeah, no, that was what I was going to say is, it depends where they fit in that regime, and if they are compliant and they have clearance to be involved in the buying and selling and the trading of digital assets, then they're as long as, provided that they're not acting as a marketplace and they are specifically performing their dealer functions, then they should be able to do that. It's just going to require some analysis to determine whether or not what they're doing is not falling into the marketplace definition.
Okay. Lily, any final comments or including in relation to those questions at all?
Just one thing, just to reiterate from a U.S. perspective, is on NFTs. That's certainly an area that I get a lot of questions on as well. And there are certain NFTs, non-fungible digital collectibles, that represent certain assets that may not be securities. but
Exactly.
there are also certain NFTs that are structured in the US that may fit the definition of a security, just the NFT itself, or fractional shares and interests in that NFT that are also being sold, and the marketplaces that support those assets. I have different discussions on whether or not they need to be regulated as a trading platform registered as an alternative trading system to rely on exemption from a national securities exchange, or if they can simply be a crypto trading platform similar to other spot market exchanges that support non-security digital assets. So all those are relevant in the NFT context, similar to other assets we discussed today.
Which segues perfectly to the final point, which is that if you'd like to learn more about NFTs, non-fungible tokens, feel free to join, as is conveniently shown on this slide, our next webinar, which is called NFTs, Why a Picture is Worth 1,000 Bitcoins, which is going to be held on May 27th. I want to thank you, Lily. I want to thank you, Lorraine, for joining this panel and giving your excellent insights on this cutting edge topic. I want to thank everyone else for joining the audience, and we're going to be sending an email out to you just about CBD credits and the next session. So thank you once again and have a great day.
Thanks, Usman. Thank you, everybody.
Thank you.
Bye.